So Chama Wontumi, the new lawyer, your friend no. The tactical Atta Edin meme di ama no. Chairman Wontumi, lawyer wababe fano in the Exim Bank case no. Lawyer Atta right now and some bebre and ekoso our political highway so now abusuya Atta right now we're filing for appeal for Chairman Wontumi the 20-year sentence na ya sentence nti no wakwa akopie mu court of appeal a echese ordin application akwa akoto akesefo anima echese sa na application or chira court ne nhwe na Chairman Wontumi the 20 years imprisonment no abusuya omontete ne omaso emfamra from anase omunjai ne kra abusuya Chairman Wontumi yade bremo se one NPP for no akuku danfo ni bi a chese omo edwane akwa akoto a president Mahama se osre oma se presidential pardon no omohwe na omotumi ja no na ono no asemo ya ato ne de biggest lesson na chese ato no obesua ade de efrem ene yeda sorry ya Chairman Wontumi ni new lawyer your friend Atta the tactical man chese only the edubuan in the case ono ene chese Chairman Wontumi the lawyer your friend no Andy Akyea kubi or withdraw from case no obeso sa Samana boy mining case ya dealing in 20 years afi no ono na asan so abeso Exim Bank case abuya mama yanko na yanko nkuti ensema course no ye ba ye de aka to am so unsubscribe ya subscribe na hit on the notification bell so send be any updates be able drop no onso wonsa ebetumi akabia ha gossip politics TV so madam I say
screen right now in the Bernardino Boysiako, that's Chairman Wontumi case, as he is in prison, at some medium prison. We understand that his lawyers have filed an appeal, a notice of appeal against this particular judgment that slapped him with a 20-year jail term. That's what you see on the screen there. On the face of it is the Republic versus Bernardino Boysiako, also known as Wontumi, Kwame Entry at large, Akonta Mining Company Limited, the third accused, notice of appeal. And it reads, take notice that the first and third accused persons, appellants, herein, who are dissatisfied with the judgment of the High Court Criminal Division 4, Accra, presided over by Her Ladyship Audrey Kokuvite, dated the 20th of July 2026, do hereby appeal to the Court of Appeal upon the grounds set out in paragraph 3 hereof, and will, at the hearing of the appeal, seek the relief set out in paragraph 4. And the first and third appellant further state that the names and addresses of the persons directly affected by the appeal are set out in paragraph 6. The part of the decision complained of is the entire judgment. So they are complaining this appeal, this notice of appeal by Chairman Wontumi's lawyers, the part of the judgment or the decision by the trial judge that they are not happy about or they are complaining about is the entire judgment of the court. That's what they are looking for right now. And the grounds of appeal, as stated there, based on what we've gathered so far, the convictions are unreasonable and cannot be supported having regard to the evidence adduced at the trial. That's A. B. The learned trial judge did not read the Minerals and Mining Act 2006, Act 703, as amended as a whole. The combined effect of Section 13(8) and 46 of the said Act is exculpatory of the first and third appellants and consistent with the innocence. 4. The learned trial judge usurped the jurisdiction of the Supreme Court in flagrant contravention of Article 131A and 2 of the Constitution 1992 in interpreting Article 1911 of the Constitution set against Section 14(1), 59, 99, 2B of the Minerals and Mining Act 2006 as 703 as amended by Section 3 of the Minerals and Mining Act 2019, Act 995, as clear when both parties have rival meanings on the words unless the offense is defined in a written law, unquote. So, in fact, the grounds of appeal are a lot more than what I've just read to you. But so far, this is what we're learning, that Chairman Wontumi, through his lawyers, have filed a notice of appeal of the judgment of her ladyship, Audrey Kokuvite, of which he is serving a 20-year jail term in Nsawam Medium Prison as we speak. And the part of the decision they are complaining about is the entire judgment of the courts. Beyond what I've just read to you, and this is what we see on the screen right now, and for the benefit of those who listen to us on the radio, just run through or read everything that we've learned so far, this notice of appeal. Dr. Palgrave Boache Dankwa is aide to Chairman Wontumi and the spokesperson for the Bernard Entry-Boesiakon Wontumi campaign team for national chair. He's joining us on Zoom right now. Dr. Bachinako, good evening.
Good evening to you, Alfred, and thank you for the opportunity.
Great. And you can first of all do confirm, beyond what I've just read, and show to our viewers that indeed the lawyers of Chairman Wontumi have filed an appeal of the ruling by the High Court last week?
Yes, I do confirm that the appeal has been filed today as at 1:40 at the High Court, and it's been received with a stamp as well. And this appeal has been filed by the lead counsel, lawyer Samuel Atta of his law firm, which is Zoe Akyea and Co. And we're happy with the progress and the steps that have been made so far. There are 5 grounds of appeal. There are some particulars of error of law, which has been spelled out as well, laid out very clearly. Some further particulars of law as well, and on the 3rd page, and some further particulars of law on the 4th page, and some gaps as well. That were not looked at. And then the final page, which is page 5, is looking at some reliefs that is being sought from the Court of Appeal. And if you don't mind, I can read that relief sought from the Court of Appeal. The first and third appellants respectfully pray this honorable court as follows: that A, enter verdict of acquittal and discharge in favor of first and third appellants on all 4 counts. B, any other reliefs that the Court of Appeal may deem fit. And this has been submitted to the Attorney General, that is persons directly affected by the appeal is the Attorney General, and it's been submitted by lawyer Samuel Atta at the High Court today.
Right, so the grounds of appeal are 5.
Yes, the grounds of appeal are 5. The 4th one I can read through. The learned trial judge acted in flagrant violation of Article 1301B and 2 of the Constitution 1992 when her ladyship refused to stay the delivery of the judgment and refer to the constitutionality of sections 14(1), 59, 99, 2B of the Minerals and Mining Act 2006, Act 703, as amended by Section 3 of the Minerals and Mining Act 2019, Act 995 to the Supreme Court for determination, and E, which is 5, the learned trial judge misdirected herself in law when in effect her ladyship held that the vagueness and or overbreadth of words as employed in panel provision in a statute is a question of statutory construction and not constitutional interpretation, while disregarding the constitutionality of the impugned provisions of the panel statutes that were actually vague and overboard in light of Article 1911 of the Constitution of 1992. So these are the 5 grounds of appeal, and then some particulars of error of law which has been spelled out and stimulated all throughout the pages of the appeal.
I see. Because what we have, and which you have just confirmed towards the full details of it, you have 5 grounds of appeal. I've just read the first 3. You have added just the last 2. But then again, there are some reliefs as well that you're seeking, correct?
Very much so.
Great. If you could run through those reliefs for us, as captured in the notice of appeal.
So the reliefs are on page 5, which is the first and third appellants respectively pray this honorable court as follows: that A, enters verdict of acquittal and discharge in favor of the first and third appellants on all 4 counts. B, any other reliefs that the Court of Appeal may deem meet. So these are the 2 reliefs.
I see. While at it, and going through this process. When was the last time you checked on Chairman Wontumi in the Nsawam prison?
Well, today I had an opportunity of visiting him and checking up on him and finding how he's doing. I needed to bring him updates on the appeal, and I confirmed to him as well that the appeal has been filed as at the time that I visited him.
I see. And are you confident in any way that these grounds of appeal will go through and find favor before the courts?
I am very confident that the rule of law will be upheld.
And prior to this moment, and the Akyea Kubi had indicated that Chairman Wontumi called him to start an appeal process, even before he was imprisoned. Is this something that you are aware of?
I cannot either confirm or deny that.
But have you sought correspondence with the Akyea Kubi to find out whether he started an appeal process on behalf of Wontumi as he requested before being imprisoned a week ago?
I haven't sought to find out that.
Would you find out that?
I think that you are belaboring the point because the appeal has been submitted and it's been submitted by the lead counsel of Chairman Wontumi, which is Samuel Atta.
I see. And beyond this appeal, that as the notice that has been filed now, what happens next? How will the coming days look like for this appeal that you have just filed?
Well, the coming days is to look at the appeal, which would be done by the judges at the appeal court, and they will determine when the hearings would be, and would also immediately start preparation towards bail pending appeal.
Well, thank you, but stay with me. Dr. Pagre Bachidankwa. Martin Pebble is private legal practitioner. He's joining us as well on Zoom for a conversation on this. And counsel, good evening. Thank you for joining us. I recall a little over a week ago when Chairman Wontumi was in prison, 20 years, you asked, in fact, you were asked a question about whether or not the appeal, if filed, because the NPP gave the notice they were going to file this appeal exactly on the day that he was in prison. That notice was given that they will appeal this. His lawyers indicated they were going to appeal this. Today we are hearing that action has been taken. They are appealing this. But you indicated that you don't really see any chance of an appeal succeeding because of the details in the judgment as delivered by the trial judge a week ago. You still stand by that position?
Oh, yes, generally. I said that generally, so let's repeat. The appeal, I said that, yes, the judgment looks good enough to be able to withstand an appeal. But of course, as a lawyer, I know that you can never say never in a court of law. But I still believe that the judgment is good enough to be able to withstand the appeal so that the conviction will be confirmed, right? But let's remember too that just the appeal alone, did they say they've also applied for bail? Because as soon as you file the appeal, the next thing is that you'll be looking for bail. And you know the High Court, as I said, the courts are about to go on vacation. So when he files the bail, if he files, he's allowed to file in the High Court, though it's not mandatory. But in the High Court, the judge, Justice Audrey Kokuvite, will be a vacation judge. When it goes before her, most of the time, the trial judge who against you will throw it out. It will be dismissed. So if it is dismissed, remember that from what we are saying, Friday is the last day. Even on Friday, the court is not. The courts are not sitting because of the 150th anniversary. On Friday, there will be no court sitting. So the next thing is that it means that for the court of appeal, unless the Chief Justice does emergency sitting for them or allows for emergency sitting, the Chairman Wontumi application for bail will not be heard till October in the Court of Appeal. I'm stressing the Court of Appeal. As for the High Court, that particular judge will be sitting as a vacation judge, so you can go before her. But as I've said, the one who has found you guilty, unless maybe with hindsight she sees a big mistake in the judgment, most of the time that same judge will not grant bail pending appeal. Most of the time they don't. So, and once that judge is sitting, it's not likely they will go and put the same case before a different judge. No. That's how come if you want fresh eyes to look at it, then that will be in the Court of Appeal. But because we are going on vacation Friday, and as I even said, on Friday there will be no court sitting. It means that if we're most likely the application for bail will be dealt with in October.
I see. That's after the legal vacation. But Counsel, stay with me. I just want to find out quickly before Palgrave leaves us. Palgrave, Lawyer Matikbebu was asking a question whether you have applied for bail. Hello?
Hello, Alfred. I can hear you.
Yes. Matikbebu was asking if you have applied for bail.
Not at the moment, but that will be done before the court will go on a break.
I see. And he says Friday they are not sitting. So when is it? You have between now and possibly Thursday.
And Thursday we have 2 days, and a lot of things can happen in 16 hours of working for 12 days, 48 hours.
We'll see how the coming days will look like. Thank you very much for joining us. Appreciate it. And Dr. Palgrave Boachidankwa is the spokesperson for Chairman Wontumi. Lawyer Matikbebu is still with us, and because we're staying in the courts. But if you're just joining us, as we did indicate, Chairman Wontumi has filed the notice of appeal. We have a copy of it. We just put on the screen. You would find it on 3news.com in the next few minutes. So that's what you have there, notice of appeal. The part of the decision that they are complaining about is the entire judgment delivered by Her Ladyship Audrey Kokuvite. The grounds set out in paragraph 3, and will, at the hearing of the appeal, seek the relief set out in paragraph 4. Palgrave Boachidankwa read the reliefs that they are seeking, and the grounds of appeal are stated there. Convictions, they say, are unreasonable and cannot be supported, having regard to the evidence adduced at the trial. And they say the learned trial judge did not read the Minerals and Mining Act 2006 as 703 as amended as a whole, and they go through the entire process. And this is it. Look, we'll wait to see how the coming days will look like on this. But Matikbebu is quite convinced that the judgment can withstand an appeal. We'll keep an eye on this particular one and see how it plays out. But still, he warned that the current arrangement could be exploited to advance political interest that anybody would have. Speaking at the climax of the Supreme Court 150th anniversary celebration in Accra, Tobias Heather, the 14th, said, safeguarding the independence of the country's apex court requires a critical review of the judicial appointment process, particularly the absence of a limit on the number of Supreme Court justices. Take a look.
As a nation, we all have to support in making the judiciary and for the Supreme Court independent and strong. One way to do it is to look or take a second look at the way we appoint our justices. From the beginning, they are made to be impartial. And also, the absence of an upper limit to a number or the total number of Supreme Court judges that allows adding, and adding, satisfy political objectives.
As the president of the Asogli traditional area, Tobias Heather, the 14th there. And if you reference Article 128 of the 1992 Constitution of the Republic of Ghana, and that's the point that he makes, and the clarion call that he joins many voices in the past to make that particular call, composition and mode of exercise of power of judiciary. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. The Supreme Court shall be duly constituted for its work by not less than 5 Supreme Court justices, except as otherwise provided in Article 133 of this Constitution. And then it goes on indicating the composition and the workings of the Supreme Court. The Chief Justice shall preside at the sitting of the Supreme Court, and his or her absence, the most senior of the justices of the Supreme Court, as constituted, shall preside. And then this, when it comes to the appointment, and you hear Tobias Heather, the 14th, talk about when they are being appointed, at the start of the process, they are supposed to be impartial, but then everything goes through and from his lenses sort of compromises their independence as well. Article 144 of the 1992 Constitution specifies the appointment of justices of superior courts and the chairman and others of the members of the regional tribunals. And bear in mind, this particular issue came up for debate when the tribunal bill was being debated on the floor of Parliament. This provision in the Constitution: the Chief Justice shall be appointed by the President, acting in consultation with the Council of State and with approval of Parliament. The other Supreme Court Justice shall be appointed by the President, acting on the advice of the Judicial Council, in consultation with the Council of State and with the approval of Parliament. And that's why every time the President, in consultation with the Judicial Council, makes nominations.
So abusuya we ne ensema ekọ so e political highway so chairman Wontumi ni new lawyer ye friend no Akyea ono ena wakọ pie mu e court of appeal chairman Wontumi right now ne appeal no ekọ so lawyer Andy appeal could be ema ya so say chairman Wontumi day na obako court akọ ne final judgment no eno ena chese of friend ne ka ne say if say and go in favor of Onua say appeal no sha say any many me ya masisa maje pene kokoti sa ensem we edema aha gossip politics TV so